Good morning, everybody. Hope everybody's doing fine this morning. My name is Ivan Garcia. I'm an enforcement supervisor for the Equal Employment Opportunity Commission in Atlanta. And with me is Mr. Thomas Rowe. He's a senior federal investigator for the Equal Employment Opportunity Commission. And we're just going to talk a little bit about what we do. What is our mission? How knowing about us could help you. I hope you don't need it, like I always say, but it's good to know that in case something so bad like discrimination in employment happens to you, then you know what to do, and that we are here for you. Basically, we are a federal agency, a federal government agency. We enforce the laws against discrimination in employment. And there's several laws, different laws that they have. They cover different bases and issues concerning discrimination in employment. And we're going to briefly go over each one of them. And if you have any questions at the end, we can actually take the time to answer them. And if we don't know the answer right now, we'll find it for you and we'll get back with you. Because it could get actually quite technical. It's not something that is written in stone, so to speak. So each case that when we investigate it is separate and independent. And it depends on the circumstances and how the law is applied in terms of the outcome. One of the questions many people have concerning the EEOC, if we are going to be representing them in the case of discrimination in employment, discrimination in employment case. Initially, the answer is no. We are neutral fact finders. What we do is investigate an allegation of discrimination in employment at the light of the federal law that applies to that particular situation. And then if we find that a violation occurred, that's when we actually could potentially represent that person. That's something I need to make a distinction about, because some people say, okay, well, I went to the EEOC, they're expecting to have like an attorney assigned to them, and don't have to pay for that. We don't charge, obviously. We are a federal government agency, but then it's not like you have an attorney from the EEOC representing you. You can actually have your own attorney, and you pay the attorney to represent you. At the same time, we are conducting an investigation of the case. So let's get into what we do. The first slide we have is what we do. Different programs that we have. When you file a charge with the EEOC, one of the first things that you need to know is that you have 180 days from the date of the alleged adverse employment action that you feel was discriminatory. So that's 6 months. Let's say, unfortunately, you're terminated. You have 6 months from the date of the employment termination to file a case with the EEOC. If you actually show up the 181st day, we don't have jurisdiction over that matter. So that's very important. That's the first thing. Second thing is that depending on the law that you're going to be filing under, if it is Title VII, which is the one that covers race, national origin, sex discrimination, pregnancy, and some other bases that we're going to go over later on. Or if it is ADA, which is the Americans with Disabilities Act, the employer has to have 15 employees or more. So if you're working for a small business that has less than 15 employees for 20 consecutive weeks, during that calendar year, then it's not going to record. So you can actually be working for a small employer, they discriminate against you, you go to us, you come to us, you won't be able to, well, you can file, but we're not going to investigate it because we don't have the jurisdiction. In terms of the Age Discrimination in Employment Act, there's a difference because the employer needs to have 20 employees or more during those 20 consecutive calendar weeks during the year where the discrimination, when the discrimination occurred, or the year before. So it's kind of technical, but we have investigators. Once you get to the EEOC, we're going to explain that to you. The only law where you don't need to have a minimum number of employees, but 2, is Equal Pay Act, which is based on like female or a male that is making an allegation that is being paid less because of their sex. You only need one other person to compare to, so that's why it's only two people. So what we have, when somebody comes to the EEOC, basically the first thing is to file the charge. The charge, we have a reception, we have investigators that they're gonna talk with you about your rights. We're gonna go in depth concerning what happened to you. We're gonna ask you a lot of questions. And then if you decide to file the charge, that same day you file the charge, you sign it, we're gonna serve it to the employer, and the employer will have to actually reply to the allegations in the charge. But before we investigate, we have a mediation program. You file the charge, we invite both parties to come to the EEOC and try to resolve the matter before doing any type of investigation. So that's giving an opportunity to both parties to actually sit down and try to settle within the first 60 days of filing the charge. It's a very successful program where you don't have to go through an investigation, you don't have to wait. Sometimes investigation, depending on the complexity, they could take up to a year. So you don't have to go through that. And you can get your relief with what you want or something that you feel like is good enough for you. And then that's it. The case is over. The case is over. If not, then it's going to go to investigation, which is the next step. And that's where the case is going to be assigned to a federal investigator. It's going to conduct an investigation, and Tom is going to talk a little bit more about that later on. And then actually, we have two other steps here. We have conciliation and litigation. Let's say we find probable cause in terms of the case. We have the evidence. We feel that we have a strong case. We are going to actually make a letter, send a letter of determination to the employer saying the EEOC found that based on the allegations that the charging party put on the face of the charge, discrimination occurred. And we're going to ask for a relief. Relief, and we're going to see that later on, has different stages. It's not only money. We have training. You could be rehired. There are so many things that could be done to actually make you whole concerning the situation that happened. But the employer can actually still say, no, I'm not interested in conciliating with you guys. If you want, take me to court, which is the next step, because the EEOC actually is a federal administrative investigative agency, which if we, let's say, don't find cause, or we find cause and the respondent does not want to conciliate, we can take the case to court, or you can take the case to court. It's federal court in that case, and here in Georgia is the 11th Circuit. Some cases, we decide that we have strong allegations, and we're going to actually represent the charging party. And at that time, we do become your advocates. And then we take the case to court. Those are some of the ones that you see in the news that sometimes is a high amount of money. You see millions of dollars, or you see hundreds of thousands of dollars, depending on how severe and the decision of the judge or the jury. So these are the protected bases we have. We're going to go into them a little bit more later on. But race, color, national origin, religion, sex, those are Title VII. Then we have disability, which is ADA. We have age, which is the ADEA. For age, you have to be 40 years old or older. I say that, you know what, because we have had so many people, younger people, I have been discriminated against because of my age, and I'm 25. Because older people have been treated better. Unfortunately, no, you're not older. You have to be 40 and older. And then retaliation. Retaliation, well, we have genetic information as well, which is something newer that we have. It was actually approved in 2008. And we haven't seen that many cases about these, but what it actually talks about, just to give you a small, information about it, let's say your employer is conducting tests. And we're talking about medical tests, some kind of testing. They're saying, okay, let me just send you to a lab, and have you had some block work done, but then the intention is to see if you could potentially in the future could develop some type of condition. So when you're being hired in the process and they do that, they say, okay, you have a family history of cancer, for example, or high blood pressure or something that I feel, I don't want to deal with. And then when they do the block work, they find out that you, most probably than not, will have something like that happening to you in the future. All of a sudden, no, we don't need you anymore. So that's what it talks about. It's something that we haven't seen that much, but it had happened. And it's good for people to actually know about it. Retaliation is at the bottom, because retaliation basically talks about when you complain about being discriminated against for whatever of those bases. You can say, I feel I have been discriminated against because of my sex. Then you're covered when an adverse employment action is taken after you complain about discrimination. But it's an unjustified adverse employment action. I have to clarify that, because many people, they just go there and say, oh, I filed a charge or I complained to HR, and 3 weeks after, they're terminated. So that's retaliation. Yeah, in essence it is. But then if you actually did something that was grounds for terminating you, then there's nothing we can do. We have to actually prove the second portion of it, that is a pretext, that is pretextual. They just wanted to fire you because you complain about a protected activity or file an EEOC charge. So these are the bases we have, and we talk a little bit about that, and I talk about the number of employees already, so we can actually bypass that one. Those were all the laws, and we're gonna go into each one of those. These are the employers that are covered and that we actually investigate. Private sector, I would say, is the major part of what we do. But we do government as well, cities, counties, labor organizations. Let's say you have a union, and the union you feel is not representing you properly, and there's some sort of discrimination being done on behalf of the union, then we can investigate it, even though there's the National Labor Relations Board as well that investigates the unions, but we can actually investigate the discrimination portion of it. Staffing companies, joint labor management committees controlling apprenticeship and training. Who are the protected individuals? Basically everybody who is in a work employee-employer relationship. That's another thing. Because if you're an independent contractor, you're not covered. You just go there on your own time, you're controlling what you do, they're not controlling your conditions of employment, then you are not an employee of that person. You're just giving professional services, or you're an independent contractor, you're not gonna be covered. But if they dictate the time when you come in, what you're gonna do, they supervise you and they pay you on a regular basis, you're an employee in essence, and basically you're covered. So that's the distinction that we have to make. What areas we cover? Basically, these are just examples. There's more to that, with hiring, firing, recruitment, job advertisements, and we have seen a lot of that where you have like age discrimination, cases where you have hiring recent graduates only. And then what about people who are older, that they graduated 10 years ago, so they're not gonna be considered? That, in certain way, and in many cases that we have seen, is a practice to actually weed out people who are going to be older. They're just targeting the 40 and over audience and saying, I just want people who recently graduated, and then my workforce is going to be younger. We have assignments, promotions, training, benefits, layoffs. That happens very often. Discipline, terms and conditions, which basically applies to any difference in terms of how one group is treated compared to another. And then it has to be related to one of the bases. Like if you say, I have a group of females being treated differently than a group of males in terms of training, uniform, equipment, all of that you need to actually do what you need to do in your job, then you're talking about different terms and conditions of employment. Or if you're talking about overtime, and then one particular group is allowed to actually make overtime and the other one is not, that's the difference in terms of and conditions of employment. An individual is a member of a protected group. We talk about that. Adverse employment actions are anything that affects your employment. The worst one we know is termination. Basically, you no longer work for the employer. And what do we need in terms of evidence? That is a difficult thing. Because in first place, when you started working for the employer, you were not thinking you were going to be discriminated against. And you're not thinking, okay, I have to be recording or I have to be keeping, saving documents or, but the minute that you feel something wrong is happening, it's good to actually try to get as much evidence as possible. What is good evidence or evidence that is, I would say, more concrete, so to speak? I would say like, if an email. Let's say your employer sends you an email, and in that email, you're requesting to work on that you're going to be off Saturdays because of your religious belief. Let's put that example out there. And then they say, no, but we need you. And you actually know that when you took this employment, this job, you were going to work on Saturdays. The employer is required by law to enter into a discussion of a potential reasonable accommodation because of your religious belief. The same goes with disability. If they don't do that and they just right away say, no, we're not even going to entertain that, that could potentially be discrimination in employment. So that type of evidence is what we're talking about. What else we can actually use? Witnesses. If you have somebody who overheard that or who was a witness of the situation, we can interview that person, and that we use as well. And there's other things that we use, but on behalf of the charging party or the person that is filing the charge, I would say that that's one of the most common things that we see. That's basically remedies. What we have is the first one and the most common one is going to be money. We have reinstatement. We have had promotions being given to the person who filed the charge because it was denied. Training for the employer is very common. We do that. Or change in terms of the policies and practices, and attorney fees if you're being represented by an attorney. We can ask the respondent to pay for that as well. These are just cases. We're not going to go through that, but those are just examples of what we talked before, the money that's being actually granted as part of the monetary relief portion of these cases that the EEOC at different offices have actually taken to court. The cost of this discrimination, basically we have financial costs, like I said, attorney fees, there's settlements, litigation. Litigation actually, that's why we are successful in terms of mediation, because litigation is very expensive for the employers. So that's something that helps in terms of entertaining a settlement discussion in case we have a situation where we have to try to mediate or conciliate the matter. For the business, when you have a discriminatory pattern, it could actually represent that the productivity is going to go down because the morale of the place, people suffering the discrimination and basically going through a difficult situation like that, they're just thinking about that instead of being productive. Turnover, people just resigning, and the reputation that we know that if a company goes out there like those cases, that goes to the news, and that has a negative impact in terms of the employers. We take a lot of charges. Unfortunately, discrimination is something very common, more common than we would think about in employment. And those are the numbers concerning the charges for 2018 and the monetary relief. That's nationwide, I gotta say. It's not here in Georgia only, but it gives you an idea of how much we're talking about, how egregious this unfortunate practice is here in the United States. Those are charge stats that we have concerning different areas of cases that we have investigated. Retaliation is the top one because, like I said, it covers all the laws. You think about it. You can complain about retaliation for sex, or you can complain about retaliation for disability or age. So it actually goes across all the different laws that we enforce. And it's very common because even though, let's say, we cannot prove that you were discriminated against because of your sex, for example, but then we can prove that you were terminated, for example, for complaining about it, then we are successful in terms of the retaliation portion of it, and that's why we have so many cases. Second one, and it's nowadays very common and very well known, is sex discrimination, sexual harassment. We have so many cases, it's the second highest. And the EEOC actually is putting a lot of effort concerning that one, especially given the publicity that we have been having recently concerning these big cases. Disability will be the third one, and then so on. We have race, age, national origin, color, religion, the Equal Pay Act, and generic information, like I said, is something kind of new, because if you think about Title VII, it was approved in 1964, and this one it was approved in 2008, so it's the most recent law, and it's just getting known right now by the public, and in terms of these novel, so to speak, practices from employers. So retaliation, we covered that, basically, is when you complain about protected activity, so I'm not gonna go too much over that. And those are the adverse employment actions that could be covered, or you could actually suffer for complaining about discrimination. Now, I'm gonna leave you with Thomas Rowe. He's gonna talk about, in a specific, about some of the laws. He's gonna talk about disability. So, please, Tom.
Thank you.
Thank you.
I had a question.
Yes, sir.
At the start, you were mentioning after 180 days, or if it doesn't have the 20 people and all that, at that point, it's no longer under EEOC jurisdiction. At that point, is there another agency that has jurisdiction, or does it just become a civil matter at that
That's
point?
something I forgot to say, actually. You can always file a charge. It's your right. Even if we know that it's not covered, you can file a charge and try to take it to federal court, and it'll be up to the judge, because you have to think about the EEOC as an administrative agency. So obviously the court is gonna be at a higher level, higher standard. So the judges, they're gonna see the cases differently. Actually, even if we investigated the case, once you take it to court, the judge is not gonna be looking into what the EEOC did. They're gonna look at everything they have in front of them and make their own decision. So there's and I can actually talk with you later on. We don't enforce this portion of the law, and you can talk to an attorney about it. My understanding is that there's another title, which is not as specific as, for example, Title VII, but where you can actually file cases that are beyond the 180 days jurisdictional time frame. But those cases, they're going to have their limitations. We're not experts on that, so that's why I'm not really getting into it that much. But some people, they just go, as charging parties, they go and file the case, take it back to their attorneys, knowing that it's untimely, and they can actually just go under that particular title and file something in the form of a civil lawsuit. But it's not going to be investigated. That's the thing. We're not going to investigate it, and I don't have any data concerning, the results of that. I guess it works, obviously, because it's an alternative you have, but it won't be under the laws that we're talking about here. So that time frame, that jurisdictional time frame or limitation is based on the laws that we enforce.
And the same thing goes for the number of employees
Yes.
that the company has?
Yes. Yeah, but most of the time, and my knowledge is that when you have such a small employers, there's not too much you can do actually discrimination-wise concerning those adverse employment actions. Because you have like small restaurants, you have 5 people working there, and they can say, I'm gonna have people from the same national origin, or I'm just gonna hire people of one particular race, and you see that very often. They technically can get away with it, because the law is not, it will take actually a change in the law from the Congress to, get coverage.
Any other questions? Okay. Now, one of the things, at the point that we decide that the commission decides that we won't investigate a charge that you bring to us or concerns you bring to us, at every point that that happens, we do issue that right to sue that allows you to file suit in federal court on your own within 90 days of the date of that letter. So don't get discouraged about stuff like that. And also the number of employees, don't be discouraged about that either. If you do find that you're discriminated against and you work in a small place, perhaps the owners of the restaurant or whatever the company is, they may have several different companies that fall under them. So in that case, we do roll the employees of all those companies in together, and we do move forward with that. So it also always benefits to at least come by and talk to someone. So we go into the disability discrimination. This is a Title I of the Americans with Disabilities Act of 1990 as amended. This is one of my favorite laws to deal with. I really enjoy working with this part. Disabilities, basically disability is anything that affects your common everyday life. Or it used to be more restrictive, but now with the amendment in 1990, disability affects just your basic functions of your daily life. And a qualified individual is someone who can perform the essential functions of their job with or without accommodation. And so if you were going along and you find that you suddenly come up with diabetes, or, I mean, there are a multitude of things that can happen to you, especially the older you get, the more we tend to break down. But you can still continue to perform your job with an accommodation, which means anything. I mean, it could be various things. Someone who's going deaf, for instance, in a factory-type situation, an accommodation may be that there's flashing lights going for any kind of warning system, anything like that. You can read along there, obviously, the slides. Disability covers physical and mental impairment. And actually, we go on the disability itself, the record of disability, or the perception of disability. And this also covers if you happen to be taking care of someone who is disabled, a child, for instance, or parents. You would be covered under the law at work. So, and when something happens where you're disabled, you bring, and we'll talk more about this, but your responsibility is to make the company aware that you have this issue going on. And usually what happens is a discussion back and forth between usually HR and representatives from the company, you and your doctor, to determine what you need to be able to perform your job. These are different examples. The reasonable accommodation, the employer has to provide that if it doesn't become unduly burdensome, or there's such a thing that an expense would be too great so that it's an undue hardship for the employer to provide the accommodation. A good example of this is a case I had one time where a nurse came in. Actually, it wasn't a case, but she did come to visit me. And I sat down and talked with her, and she had MS. And it progressed to the point where she was shaking. She was a registered nurse. And it got to the point where she was shaking so badly that she couldn't give IVs or take blood or give shots or anything like that. That is one of the essential functions of her job that can't be overcome, unfortunately. We couldn't do anything for her because the only way to keep her working would be to have another registered nurse tag along with her. That's not logical. you know. You're paying two people for what one person could do. However, if on the other hand, she had an issue where she couldn't lift over like 20 pounds, but yet she's in, you know, nursing, you have to push, pull, lift a lot, or doctors. An orderly could do that kind of thing. So that would be an accommodation that would work for a registered nurse. Just an example. Any questions so far? Okay.
I think it's very important to remember that you have to start the process. You have to request the reasonable accommodation, and then the employer entertain the conversation of accommodating you. Because some people think, oh, well, you know, they see that I'm limping and they're not accommodating me. You have to request it. You don't do it, they don't have to do it.
And these are examples of undue hardship for the employer. Significant difficulty or expense in relation to the size of the employer, all right, their financial resources, and the impact of the accommodation on the operations and facility.
But that's something that they will have to actually prove during the investigation.
Yeah.
You see, you file the charge, and then they have to prove that it's an undue hardship. No, not to you, actually. They can tell you no, and they will say the same thing, then you have the right to file the charge, and many times we find out that it's not.
Right. One case that I had was a very large employer, a grocery store, and the lady came in. She was, and sometimes you don't know, and this is where we go as regarded as disabled. So she had an accident. She was out for 6 months, having surgeries and stuff like that. But she came back to work. Now, she worked in the deli, and comes back to work and thought that she'd be okay. And it turns out that during the day, she started swelling up her leg, you know, started swelling up her knee, and she couldn't stand all day long like she had before. And so the employer told her, no, you know, you can't work until you're 100% better. And for us, even though she's expected to get over that eventually, you know, maybe a couple years down the road, it'll be a non-issue. So she's not really technically disabled, but in this aspect, we consider it as regarded as disabled. Nonetheless, disabled or not, she still has the right to work. Now, what accommodation would be a stool that she could sit on, you know, when she's not actively helping a customer, you know, not 24 hours a day, our customers up at the deli counter, you know, so there are times. And her doctor provided an excuse, say, please allow her to sit down as needed to relieve the pain and swelling in her legs. And the employer's answer to us was that they, honestly, they said they took that to mean that she would be sitting down for the majority of her shift. And so they denied her. So that's one that we did go cause on. Because it's a simple matter. You know, it doesn't cost them anything. I'm sure there's a stool sitting around somewhere in the manager's office just waiting for her to use it, you know. So that's an example of reasonable accommodation. Applying for a job, there's another one, an example that how this would work also. Had a gentleman come visit, and he's legally blind. I think he told me he could read comfortably a size 18 font. But he applied to be a bagger at another grocery store, and he was accepted. He had done it before for another chain, and he went through the interview process and was okay. Went to do the in-processing paperwork and stuff like that. The company had all their paperwork, or the majority of the paperwork, on the computer so he could digitally sign. But the general manager of the store, who hadn't seen this guy before, comes by and notices that he's looking at the computer screen through a magnifying glass, and asked him to come into the office and talk to him, and found out he was legally blind, and told him we're not going to, basically fired him because he was already hired, right? So, so, you know, then when I went through the job description of the bagger with them during the investigation and asked them, what are these items that you feel that he can't accomplish? Well, you know, we need to keep cooked meat separate from raw meat. So if they go to a deli and get a rotisserie chicken, and then go to the, you know, and they're also buying a raw chicken, you know, the bagger, you know, needs to know not to put them in the same bag. I'm thinking, does that have anything to do with even being able to see? I mean, you feel, right? You feel heat. But, you know, it's everything. The guy said, no, I don't. Well, did you take him down? I asked the manager, I said, did you take him down and let him try to do it? Did you watch him do some of these tests? No. So how do you know he can't do them? You know, another issue. So that we went cause on that one too. Okay, some of the types of accommodations that can be done. Job restructuring, modified work schedules is a big thing, especially when you're dealing with someone whose parents are ill or you've got a child with autism or something like that. You may be able to modify your work schedule in order to take care of that child, get them off to the school or wherever he or she goes, and pick them up at night, make sure they get to the right place. Telework's possible. Now, if telework's not available at the job, then that might be a little bit difficult. But a lot of times nowadays it's possible. Not every position can telework, obviously, though. Leave. Accommodation, we see a lot of this where we have really restrictive leave policies where, and there's a large company right now that we're dealing with, who they said if you run out of your FMLA, and I'll talk a little bit about FMLA too. If you run out of your FMLA, then you're out of luck. You know, you can't, during the 12-month period, you can't, you have to come to work or else we don't have a job for you. And that's really restrictive. Leave can be unpaid leave, which is always an option. Now the courts, the federal courts, tend to look at undue hardship for leave. Now again, it depends on the size of the employer, but if you're like, for instance, a telecommunications company, or you're doing customer service over the phone for a large company, you're going to have maybe several dozen of the same type of employee, answering phones, doing customer service, stuff like that. It doesn't hurt. One of the accommodations we would expect to see is non-paid leave if you don't have any paid leave left, right? However, the federal courts have determined that usually 6 months or more for any employer is a little bit of a hardship. So if you, for instance, unfortunately, if you do have cancer and you require a little bit more than 6 months leave to get over that, to get to the point where you can come back to work, then that may be an issue that we can't overcome as far as an accommodation. Modifying equipment or devices and job application procedures. Another thing with that blind gentleman I was talking about, one of the things we're going to have that company do is one of the things I did do when I did an investigation is I looked at the online in-processing thing. They had the little videos explaining some of the job procedures and stuff, but the videos on the computer screen is normal size. The videos were only this big. And when you tried to enlarge the video, instead of it going full screen, the screen may got bigger, but the video itself stayed small. So one of the things we're going to have that company do is change how the in-processing works. It couldn't increase the font size for the the documents online that you're supposed to read and sign. That was undoable. So those are things that are going to have to be changed to fulfill the conciliation for this type of job. Readers and interpreters. Many, especially in the South, you have a lot of Hispanics that don't speak English or have a hard time. There's nothing wrong with having, having interpreters available if necessary. Okay, sign language also. Yeah, absolutely. You can get on www.eeoc.gov and find a lot of information. And you'll see here in these examples of the EEOC cases that Yvonne showed you earlier, and you'll see some more up here for the disability. Those two sets of slides, all these cases were finalized in the last 2 months. Okay, so they're really recent. There's a third slide later on that I don't know how old. I think that was within the last 6 months. I talked about the 100% healed policies. We don't like to see that. People should be able to not have to take leave when they can still work. There should be some sort of accommodation for everybody to come back to work. Unless you're doing something heavy, that's your entire job is like lifting trash cans into the back of a truck. There might not be a whole lot of accommodation for that. Unless they happen to have a job inside the office that you could do for a couple weeks. But once again, it's taking a look at the job function, the size of the employer, and all that. Time and attendance policies can be adjusted sometimes. Here are some of the cases. Like I said, these are in the last month. I believe all these were settled in last month. These aren't the ones that have been filed, but these are the ones that actually settled from EEOC standpoint. These we actually litigated and came up with this, or the conciliation. Some of these are conciliation, some of them are litigation. You can read those on your own. The FMLA, we don't enforce FMLA. That's the Department of Labor. But we do use FMLA as it touches the ADA as an accommodation. Okay. So we do deal with FMLA a lot, but not the mechanics of it. We deal with it as an accommodation for the ADA. Harassment's a big thing. We're seeing more and more of the harassment allegations coming in. Just because someone doesn't like you doesn't mean that that violates the laws we enforce, okay? And we see a lot of that. We see a lot of that. We see conflicts between supervisors and employees due to bad management skills a lot of times. Unless it has to do with race, and we can prove that, sex, age, and there's really not a whole lot we can do. And that's where we determine on intake, when you come in to see us, that's where it becomes important that we see any documentation you have. A lot of people say, oh, I left it at home or whatever. It doesn't do us any good, because we do make an initial assessment whether we're going to investigate or recommend it for investigation based on your credibility, based on any witnesses you might have, based on the any documentation you have also. There are many more things that we look at when you come in to the office and talk to one of us. But basically, you need to be able to, when you talk about harassment, it's got to be founded in one of those laws that we enforce. Okay. Race or color. Anybody know the difference between race and color as a basis for discrimination? Race is black and white, Hispanic, Asian, however that may be. Color is the difference between discrimination within the same race. So you're dealing with lighter skin and darker skin. Okay, that happens a lot in Latin America, where you have a heavier, African influence in some families, or in other families you have a heavier Spanish influence, or Indian. So you have various shades skin colors within the same race. And that's where a lot of times people think that, okay, you're from more Spanish descent, so you're more favored. So that's where we get color. Sex, religion, national origin, age and disability. Genetics should be on there. But once again, we don't see a lot of harassment based on genetics. Sexual harassment, of course, you've seen this, you should have seen this time and time again. Unwelcome verbal or physical conduct of a sexual nature. This can also go text. Starting to see that a lot. Texting. And if it alters the conditions of employment. What we say when we're dealing with harassment in the workplace is it's got to be either severe or pervasive. Pervasive means that you're getting these slurs all day long, every day. You know, every time you come to work, you got somebody that's always calling you names based on race again, or sex, or something that we enforce. Severe would be more a one-time thing that's just egregious. Like, obviously, rape would be severe. Having a noose, you know, in your, on your workstation when you get to work, that's another severe act. An occasional utterance of a slur, not really enough to do a whole lot, right? Now, these things also change, though, when you get into management. Supervisors and managers, people who have the authority to hire, fire, or change your employment status one way or another, these people we hold as being the same as the company itself doing it to you. They should know better. So anybody who's a manager, supervisor, it's pretty much guaranteed that we're gonna go after it hard, because they should know better under that. Got a case right now with the company whose general manager was sexually harassing a 16-year-old. And she went on with it for a little while. He was 34 years old. She went on for a little while. You know, he was kind of like getting in there with the text messages. I don't think she realized what was going on until he was actually very crude at one point. And just because the rest of the company doesn't know about it, or the owner of the company or CEO doesn't know about it, he was a general manager. He should know better, so he acts as the company.
Does that include sexual orientation?
Yes, actually, yes. We consider that. Now, our district, the 11th district, does not consider that part of Title VII. We do. So sexual orientation, we deal with sexual orientation, gender identity, anything like that, we go ahead and we'll do a charge. Regardless if the district, 11th district, doesn't agree with it, we still do that. So we can do a charge, and we'll investigate a charge and even litigate a charge if necessary based on that. It's eventually going to happen. You know, it's like, you know, a lot of other things. It's going to take a little while. It may not take that much longer, but eventually it'll be recognized, I think nationwide, that, you know, federally, that sexual orientation and gender identity also fall under Title VII. Any questions? No? Examples? I'm sure you've seen this again, time and time again. All right, see, these are some of the cases here. These are the ones I was telling you that I think these may be up to 6 months old. All these should be sexual harassment or some sort of harassment suits. Once again, if you go to the EEOC.gov, you'll see a newsroom think it's on the left-hand side of the page when you open it up, and you'll see some of the recent filings, court filings, and some of the recent settlements, which these are. And you can look at this, see the details of the cases. Some of them are, you'd be like, I don't even know. I'm still amazed how far we can get into investigation before the company finally, says, yeah, we did the wrong thing. Well, most of the time, they don't even say that. They just, do the settlement and conciliation. I've had one time where allegations were made, and once we filed the charge, I think the company's lawyer called me. I was on the way home one day. The lawyer called me about 2 weeks afterwards and said, look, I started talking to some of the employees about what the allegations were in this charge. And I talked to more and more. I talked to all but maybe 5 employees of the company. What can we do to fix this? Because it's bad. So that was the only time I've actually had counsel say, yeah, they messed up bad. We need to fix it. Tell us what to do. We'll get it settled right away. Hostile work environment. Once again, we're seeing a lot of hostile work environment, but it's not based on any of these things that we enforce. It doesn't mean it's right, but there's nothing we can do about it. That's when that right to sue becomes valuable, because we get that to you, and then maybe a lawyer can do something with it in court. And again, sometimes, as soon as we take a charge, we have 10 days by law to send that to the employer. So the employer, a lot of times when the employer sees that, and they see that it's being known what's going on within the company, even though it's not made public, it still is, should be concerning when they see that, So maybe the employer takes steps on their own, even though we don't investigate it, to make some of these corrections.
Sorry.
Yes, ma'am.
Is it saying that if someone discriminates against you, that they would give you a promotion and that fixes it?
No, not necessarily. But what happens here is, what that means is part of the settlement process. Like Yvonne was talking about, you have mediation. There are different times when a settlement comes into effect during the investigative process. Once we take the charge, mediation is the first step. We try to settle things at the lowest possible level to reduce costs to the government. So if you were denied a promotion and you feel like the promotion would be good enough that you settle the case, and not move forward with it, and they agree to that, then that's what, that can be done during the mediation. Or any time, yes, ma'am?
I guess I was going to ask you, if you decide not to go through the legal mediation, and you're just dealing with your employer, is there something that you need to maybe get in writing, kind of stating why you got a promotion, or that it came from this harassment situation?
I'm not understanding really.
Like if you were just to go through your employer to handle it, and they say, okay, I'm gonna give you a promotion, to help with this situation, if you don't, go to a mediator, you're like, okay, fine, but is there something you need in writing that says, this is what the company decided, they gave you a promotion because.
This is after you've come to see us?
This is if you don't.
Oh, if you don't. I mean, that's up to you. It really, I mean, if you think that no, but yeah, and we're not going to see that, and it doesn't really affect anything we do. I mean, we don't get involved with anything like that until you come, unless you come to.
Let's say you take that, that offer from your employer, and then something else happens
Right.
later on, then you go and file a charge.
Yeah.
Okay, and y'all aren't gonna look at that and say,
Because
well, if they
because
gave
you filed a
promotion
charge.
last time,
Yeah,
you should be okay
no,
with it.
yeah, because you filed a charge based on the adverse employment action that is taken against you. So if you actually settle with them and everything is fine, you're fine, but then something happens in the long run. Let's say you complain about discrimination. They gave you the promotion, and within those 6 months they do something, you can file under retaliation. Because it was just something to fix the situation, thinking that maybe she's not gonna complain, wait the 6 months and then do something.
Yeah.
But then once they do that, that's your first day of the adverse employment action, so you have moving forward 6 months.
Oh, I
You see? So,
Okay,
yeah.
so the promotion.
But then, yeah, I will actually get it in writing, you know, if I was you, because you want to have something that you can show later on about the promotion.
Right, yeah, I don't want the promotion, if a harassment happens again, I don't want the promotion to act negatively
It should not.
on you.
You always have the right. Even if you conciliate, even if you go to court, you always have that right.
And we look at that
File a
too.
charge again, if need be.
Yeah,
Yeah.
and so if you come in that situation and you file a retaliation, like Yvonne says, because you've made that complaint, and you have to be specific when you make these complaints too within the company. And we want you to do that actually before you come here. It's like, you can't go to federal court with, you can because you can do just about anything, but your suit is not going to be entertained in federal court unless you exhaust your administrative avenues by coming to us first, okay? By the same token, we ask that you go to your company and make them aware of what's going on so they have the chance to fix it before we get involved. And so if you do it like that, and you're talking about that, and that happens, you've made the protected complaint, and Yvonne's right, we would do that as retaliation if something happened after that, because you've already made the complaint. Hopefully you have an email or some sort of tracking that shows you made that complaint, and then they gave you the promotion as a result. And then after that, whatever they did to you caused you to come in. And even though they can say, yeah, we gave her a promotion because she complained, whatever, but we see through that.
Yeah, we see that very often. That,
Yeah.
You know, you talk to the employer, there's nothing in writing, guess what? They're gonna deny it, so it's gonna be your word against.
Yeah, absolutely. I mean, this is
And we were not there, so who are we gonna
Yeah.
believe?
yeah, we have to, in order, yeah,
There's no evidence.
and there's a,
If that company decides to do that, what if another employee comes to you all and files a complaint saying this person was promoted, the job wasn't posted, how?
A person could do that, then we have to investigate it. Yeah. And see, yeah.
and if that wasn't based on anything, so, yeah, it's a whole process, but we,
So would the employer be found at fault for doing that?
Not necessarily, you know, it depends on the circumstances, and if it is a case like that, and then they did it to fix a situation that in the face was discriminatory, it depends, it's on a case-by-case basis. But then if you're using that to cover up some kind of favoritism based on race or sex, or yes, then it could be a violation. So that's why we have to investigate. But everybody's gonna have the same right to file a charge, depending on how they feel, because at the end of the day, it's about how you feel. Do you feel discriminated against, and you have the right to file.
there's a lot of things to look at. And this is why sometimes these investigations take a little while. How many of y'all are in the HR area or something like that, working there? Okay. This is, we're getting in the part where this is geared more toward the employer itself. So if you happen to be in a leadership type position, or a position where you can drive a little bit of the policies going on, this is what we ask. Now, HR is, I've got a master's in human resources management, and HR is very tricky when you get into the company, because you have the laws that you have to make sure are followed, but then you're servicing the company as well, and also the employees. So you're driving a very thin line there as far as what you do. I believe this can be found in the EEOC.gov as well. You should be able to search it. Yeah, Task Force on the Study of Harassment in the Workplace. The employer's responsibilities as far as the laws go is that to ensure that the employment decisions are not based on race, color, sex, religion, national origin, age, disability, genetic information, or retaliation. sometimes unintentional things happen and that create a disparity between races or sexes, and it's actually unintentional, but it turns out to be that way. A good example is a large car manufacturer that I investigated, and to my knowledge, that this charge has not been, the set of charges hasn't been resolved as of yet. In order to get promoted, they required to certain, like group lead, stuff like that, this factory. They required for the applicants for promotion to, aside from seniority and all that kind of stuff, and obviously attendance and performance evaluations, they required them to take a test. And the test was more of a psychological type test, I guess, to see if they were, I guess, the type of person that they wanted in leadership positions. Not bad on the surface of it. But the interesting thing is that the workforce was predominantly African American in the factory. So you had, let's say 2/3 was African American, you have a third white, and some Hispanic in there. But the numbers of people who applied to be, from each race, who applied to be the group leader, for instance, if you take the total number of employees of that race compared to the number of people who applied to be group lead, and then the numbers of the races, the numbers of each race that actually got the group lead position, the chances of that turning out the way it did in that factory was 0.27% of a chance, which is totally outrageous. So you find out there's something wrong. So there's nothing wrong on the surface of things, but the policy, when we looked at the testing, we realized that there were some questions in the test that kind of tended to weed out African Americans. And I'm not going to tell you what those questions were, but when you look at them, it was kind of like, yeah, you could see where that came from, you know, where that might work. And these type of things are very, very tricky. Testing should not be done for promotion unless it, or even for hiring unless it actually pertains to the job being done. If you do have testing, testing should be, well, we require the companies when they have testing, they're required to go back and check and see what the results of that testing is every year, and to modify the policy a little bit if in this case it shows that the testing inadvertently favors one group or another. And that case is still, it's at DC, the statisticians, a bunch of people with doctorates are looking at that case still because it's so esoteric as to what's happening. So these are things that it's not overt discrimination policies, but it's something that's been going on that after a while you can see, hey, you have to ask why, if you have 100 white people and 300 African Americans and everybody wants to be a supervisor, how come 75% of the supervisors are white? It doesn't make sense. Something's wrong, okay? One of the things that help the companies a lot is once they find out, if they find out that some sort of violation has occurred, to take care of it immediately. Things happen, and we have had people come in to file a charge, and what happened to them was egregious, but as soon as the company found out what happened, they went and did their best to try to fix it right then. In that case, we don't have, you know, we usually won't do anything because the company is trying to make it better without us having to step in, okay? And we're certainly not going to try to just in the same way, we're not going to accuse a company of doing wrong if there's no evidence to start an investigation. We want to kind of encourage them to keep doing right when they step in and try to fix it before we get involved. Here's your rights and responsibilities. You have the right to work free of discrimination or harassment. You may have seen in one of those first slides, it doesn't matter if you're here legally or illegally. As long as you're employed, you have the same rights, all right, to work without harassment. There are a lot of unfortunately undocumented workers who are sexually harassed every day in the fields and doing whatever, and they don't come to see us because they're afraid that, you know, we're going to talk to the people who get them out of here or something. You know, I don't know what the thought is. It's fear. And the employers prey upon that as well because they know that it's not very likely that these employees will go forward and say, hey, I'm being raped every day in the field or every week because they're scared of being sent out. Okay? Your medical information should be kept separately from your regular personnel file, but that's something we deal with, but they should not, you know, your medical information shouldn't be out there. All right, and you should be able to complain about the job discrimination without retaliation. All right, your responsibilities, don't harass or discriminate against other people. Report discrimination when you see it. Preferably, again, have it in an email or something like that you have some sort of proof you did that. Request a reasonable accommodation, either religious or disability, when necessary. Obtain a copy of the employer handbook and read it. All right. This is it. All right, this goes for the employers. You can read that on the slides. I'm getting low on time. Does anybody have any questions? Anything at all? Yes, sir.
Is narcolepsy one of the covered?
Yes.
I know Georgia, how big is the 11th district? As much as state, correct?
11th district covers what?
Georgia, and there's a portion of South Carolina, and just a couple of counties in Alabama as well. So that's it, yes. But it's mainly Georgia. We have an office in Savannah as well, a local office.
I asked that question because I know as far as I know the physical disabilities, I know Georgia's vocational rehabilitation agency also does provide some assistance to employers as far as funding accommodations. Is that something that you all see in the other states?
Alabama has something similar to that as well. And I didn't actually know that Georgia had that. So I would love to have some information if you could get with me, if you know the point of contact and all that, because one of the things I like to do personally, I think everybody does, we don't live just to, you know, jump on employers. I actually prefer to go and do something like this and educate them, especially smaller companies who are just starting to come up. And I would dearly love to be able to go and say, hey, this company, you know, if you're at a loss as to what to do to accommodate this employee, talk to these people because they'll help you. Alabama had that. I started out in Birmingham district with the EEOC, and they had a company that was or an organization that was nonprofit that was very helpful and involved with those things. I'd love to have that information. Anything else? Anybody? All right. Y'all should have my card. Most of you, I think I ran out, but anytime keep saying I've got 5 or 6 years before I retire. Until then, send me an email if you have any questions at all. I would rather help out answer questions before a problem became a problem and have to do an investigation, although I get paid either way. But yeah, please don't hesitate to call me or send me an email. All right. Thank you, ladies and gentlemen. Appreciate it.